to ask you a question about most recent developments. Want to talk a little bit about your Johnson and Johnson trial, your $4.69 billion verdict, which was incredible, and the impact that you made, right? The company took the product off the shelves in America and Canada. A lot of good was done for the people that you represented, their families, monumental win for a monumental issue that had never been litigated before. What happened next was that Johnson & Johnson filed for bankruptcy, and they won the trial, and now it's held on appeal. What do you think is going to happen? And did you see it coming?
Yeah, I did. In fact, I tried to get everybody that still had cases pending, because ours were resolved. We resolved all our cases. Right. I tried to get everybody to settle with Johnson & Johnson because Johnson & Johnson was willing to pay a certain amount of money. I thought up to like $5 billion. And I think the negotiators from the victim side thought they could push them just a little bit further. And Johnson & Johnson said, no, if you don't take it at this point, that's as far as we'll go. If you don't take it, we're going to file for bankruptcy. And I think the lawyers for the victims didn't believe Johnson & Johnson and said, oh, you will not. And lo and behold, they did. And now everybody's like, oh no, who'd have thunk? I thought, yeah. Well, anybody with their eyes open, but I don't know how it ends. I think there's going to be a major fight over it, maybe going all the way to the U.S. Supreme Court, because Johnson & Johnson as a company certainly has the money to pay. And so they're using this unusual Texas law to try and cut off their exposure. And it's called, in fact, the Texas two-step. Because it's a two-step process. And I don't know at the end of the day if it will work or not, but it's certainly worked right now with the bankruptcy court on that level.
So if they win on appeal, do you think that's sort of the beginning of the end for the mass tort world? Or is it going to just be a wild card depending on the project, depending on the personalities involved? How do you see this trickle down into other areas of the law?
Marina, I think it'll be a wild card. I think it will be a case-by-case basis. I think the Texas law is really geared and written to apply to asbestos situations. And so Johnson & Johnson gets there off the talc product because there's asbestos in the talc. And that's the core of that allegation. So I think that it works in that situation, but most pharmacy cases are not asbestos based. And so it would be another huge extension of the law or the principle to take it into those run-of-the-mill pharmaceutical cases. That being said, it is a roadmap. And it's one that I wouldn't be at all surprised to find other defendants trying to follow. But understand, even in the asbestos world, some companies have used it, many companies have not. And so it's not used all the time already, even in its limited context.
Yeah. What did you think about their arguments and ultimately the judge's opinion? Did you find that there was strength in their arguments?
I did not like I did not agree with, I should say, the Johnson & Johnson argument. I did not agree with the judge's opinion. The judge wrote an opinion where he basically says, plaintiffs think that they should be in the court system, trying these cases to jury. I believe that you can get a much fairer, prompter resolution just going through the bankruptcy court. I'm sitting here thinking, well, at the law school you went to, did they not explain that the right to trial by jury is actually a constitutional right? Mm-hmm. And you can't be a bankruptcy court and just say, well, maybe it's a constitutional right, but I don't think it's a good one, so I'm going to strike it down. I mean, the the Marbury versus Madison does not give bankruptcy courts the right to strike down the U.S. Constitution, even if it's in dicta, and say,
Right.
well, maybe, yeah. So I think that was, I think that was an outrageous set of language and concept by the bankruptcy judge.